Procedure of amendment in the U.S. Constitution. Introduction. The U.S. Constitution is written rigid. It is rigid because the process of its amendment is very difficult and complicated. A special method is required to amend the Constitution. Due to this reason that only 26 amendments have been made to the Constitution so far. Process of amendment. Article V of the U.S. Constitution prescribes the amending process. Stages of amending process. The amending process has two stages, one of the proposal and the second of ratification. These two stages can be conducted in the following ways. A. Proposal initiated by Congress. An amendment may be proposed by a 2/3 majority in each House of Congress. It must be ratified by 3/4 of the total number of the states. The ratification may be done either by the state legislatures or by the special conventions held in the states for this purpose. B. Amendment initiated by state legislation. The states may also take the initiative in proposing amendments. If 2/3 of the state legislatures apply to the Congress for this purpose, the Congress calls a constitutional convention which shall, based on the original recommendation, propose the amendment. These amendments must be ratified by 3/4 of the total number of states. The ratification may be done either by the state's legislature or by special conventions held in the states for this purpose. Modes of ratification. The modes of ratification are to be determined by the Congress. Time limit for ratification. Formerly, there was no time limit for the ratification of a bill passed by the Congress. It is stated that in one case the ratification was made after 80 years. However, the law has been changed and it is provided that the whole process of ratification must be completed within 7 years, and if it is not done, the amendment falls through. Assent of the President is not necessary. It was held by a Supreme Court that an amendment is solely a legislative function and the President need not assent to a proposed amendment before it is sent to the states. Restriction on amendment. The Constitution has itself laid down certain restrictions on its amendment. A. Article V of the Constitution says that no state shall be deprived of equal suffrage in the Senate without its consent. B. Article 4, Section 3, I, of the Constitution says that a state cannot be divided into 2 or more states, nor 2 or more states can be combined into one without the consent of the legislature concerned. Criticism of the amending process. Following defects have been pointed out in the amending process of the U.S. Constitution: A. Unadaptability. The U.S. Constitution lacks the virtue of adaptability with the change of time. It can be shown by the proposed amendments, which were more than 4,000 since 1787, and only 27 secured the requisite majority. B. Slowness of process. The amending process is very slow, involving 2 stages of proposal and ratification, and the Constitution has also not prescribed a time limit for ratification. C. Against the spirit of democracy. U.S. Constitution envisages, consent of the states and not the majority of the population. For example, 13 small states with say 1/10 of the total population may prevent 9/10 of the people from effecting any change in the Constitution. This is considered to be against the spirit of democracy. Conclusion. USA's Constitution is a living organism. The rigidity has only been provided as the fathers of the Constitution were cautious to avoid all possibilities of capricious, erratic changes in the Constitution.